Good afternoon. Welcome back to In the Office with Scott and Wallace. As you can tell, the day's too pretty for us not to be outside, so we thought we would broadcast from outside our office here in Tallahassee. And as long as the cars cooperate, hopefully you can hear what we have to say today. Clint, the topic today is disputed liability accidents.
Okay.
As we've talked about on several occasions, we practice in 3 different states.
Sure.
And as luck would have it, there's 3 different sets of laws that apply or could come into play whenever there's a dispute as to how an accident happened.
Okay. And they kind of illustrate the whole country's gamut.
It does. It does. And so, beginning, since we're here in Tallahassee, why don't we start with Florida?
Sure.
And talk a little bit about comparative fault.
Sure. Well, to start with, what is fault? And fault is if we end up having a trial in a case, and at the end of the case, we ask a jury to assign percentages of fault to the various actors, and they can go from 0 to 100% on anybody that's involved in the accident.
Or someone, I should clarify this because I think you're going to get to it anyway, but not just people that are in the lawsuit.
Correct.
But anybody that may have had a role in causing an accident.
That's correct. And some common reasons that you'll see fault assigned to an injured party might be they weren't wearing their seatbelt. That's a very common reason. Or there's a dispute to the accident. One driver says they had the green light, the other driver says they had the green light.
Very common scenario.
And so we present evidence to a jury, and they decide who they think was at fault for the accident. And their determination matters depending on the venue to a great extent. So Florida has something called pure comparative fault. And in that scenario, the jury assigns their percentage 0 to 100, and the plaintiff can recover his percentage of damages even if he has some fault, he or she. So for instance, in a case, let's say it was a 50-50 case. The jury says the plaintiff's 50% at fault. In Florida, the plaintiff gets 50% of his damages.
The awarded damages.
So if his case was worth $100,000 and he was 50% at fault, he'd be entitled to $50,000.
Judgment. Exactly.
For a judgment for $50,000. So in Florida, that's what pure comparative fault is.
Okay.
All right, let's try.
Now take the same example.
Okay.
Let's move up to Georgia.
Okay.
So now we've got that same accident. It's a 50-50 allocation of fault.
Right.
All right. Jury comes back with a $100,000 verdict and says the injured plaintiff was 50% at fault and the defendant was 50% at fault. What happens in that case now?
In Georgia, they're under a modified comparative fault system, which means if you have 50 or more percent of the fault in an accident, you get 0. So in your scenario, if that happened, they come back and says the plaintiff's half at fault, and the plaintiff gets 0, which is potentially unfair because if they came back and said the plaintiff was only 49% at fault, then he would get 49% of his, or 51% of his damages.
Right.
And so in Georgia, if you're between 0 and 49% at fault, you can still recover. If you're 50 or more, then no recovery.
Now, before we get into Alabama, this interplay with how an accident happened and what we think the evidence ultimately will be in a case is something we have to keep our minds on when deciding whether or not to pursue a case or to litigate a case.
Case value?
Case value, because hopefully, as you can tell, in Georgia, if we think there's going to be an honest dispute about what happened and we think our client may have 50% or more of the negligence, well, that's a case most likely we can't litigate, or at least can't try, because that's not going to work out in our client's favor.
Sure.
Versus in Florida, like for example, we tried a case about 18 months ago in Panama City where our client was killed in a car accident. He pulled out in front of another car, and you'd say, oh my God, well, why would you be trying that case? Well, because he violated the right-of-way. Well, the accident happened at night, and we proved that the other car didn't have its headlights on. And so we anticipated our client would have some fault for violating the right-of-way, but we also felt in our hearts of hearts that the defendant would share responsibility.
Sure.
That's just another example.
And that's why I think, in my opinion, Florida's system is the most fair, because it's not an arbitrary cap with percentages. It's, if you were 90% at fault, you get 10% of your damages.
Now talk a little bit about Alabama. Probably the most penal of them all.
Yeah, Alabama is the most penal. They're one of 3 states that has pure contributory negligence. So what that means, if you have any fault, 1% at fault, then you complete bar to recovery. So for instance, if you're in Alabama and you
we're going 1 mile over the speed limit.
1 mile over the speed limit. Exactly. That's a good example. Then if a jury finds that that's some allocation of fault, then you're completely barred. And so that's one of the more archaic thoughts on comparative fault.
Unfortunately, that's the rarity, right?
Sure,
or the exception, I should say. I mean,
so all of these are illustrations as to why, if you have an accident, shortly after the accident, insurance companies are going to call you. They're going to want to take recorded statements or have you fill out paperwork. In all 3 of these states, it's important that you don't go ahead and give a recorded statement. Talk to an attorney first, okay? Because the reason why insurance companies are doing this is to try to establish future arguments for comparative fault.
Yeah, and so in a disputed liability case, you may be cited for an accident by a police officer who didn't see the accident. It's not the police officer's fault he didn't see it or she didn't see it. They're investigating as best they can, and one driver's saying X, the other driver's saying Y. And you may think, well, I don't have a case. I just got cited I'm injured, but I just got cited by the police officer. I don't have a case. That is not the correct way to think about it. An investigation may reveal independent witnesses who can clarify actually who had the green light. There may be surveillance video at a gas station, for example, that shows the accident or shows the light at the time of the accident. So these are just some simple things simple types of evidence that can be collected that may turn the tide in a case, and it's not much of a dispute.
Sure, you're right. And most of the time, what the police officer's opinion as to what happened is not admissible. Okay, because usually it's a guess. He or she likely didn't see the accident, unless they're an accident reconstructionist and they go back and recreate it. But most of the time,
and you only see that in homicide investigations.
Correct. So that's an analysis of comparative fault. If you have a question about a case you're in, just give us a call. We're always happy to give you the analysis that pertains to your particular case.
And it is really nice outside. I feel like I need to move my desk out.
I like it.
But anyway, I hope y'all get a chance to get outside and enjoy this pretty spring weather. And if you have any questions about your accident, or if there's a dispute as to how an accident happened and you want to talk to us, call us or email us. We're happy to help. Otherwise, we'll see you next Tuesday at 2 p.m.
All right, guys. Thanks.
Thanks.